This is a test. call this special workshop to order, 4 o'clock. Reverend Mulberry,
Yes, sir.
would you please rise and let's say the invocation, please?
Absolutely.
Thank you.
Father, here we are again in your presence. We say thank you for how you blessed us throughout the day. You brought us together once again to do the business of the city. And we pray, God, for your guidance, for your directions, and for your instructions. Touch our hearts and minds and give us to make wise decisions in a time such as this. We'll give you praise and glory for all that you do. We thank you in advance. In Jesus' name, amen.
Amen. Would you join me in the pledge of allegiance to the flag? I pledge allegiance to
the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Ms. Krantz, would you call roll call, please?
Chairman Killebrew,
Here.
Vice Chairman Deloach, Mrs. Owens, Mrs. Rawls, Mr. Barnes,
Here.
Mr. Wallace, and Mrs. Wilson. All present and accounted for, Chair.
Thank you. After our last meeting, I had a conversation with Mr. Holmes, and I had asked that we kind of have some instruction, and that's the reason we're doing what we're doing tonight, just so we can all get back on the same page with what we're doing. Okay. I don't think there's any reason to read the attachment for the appeal. So with that said, we'll move on to the first part of this, which will be the planning board rules and definition per the Polacca Municipal Code. And Ms. Lisa's going to do that for us.
Now it's on. There we
Okay.
go. Good afternoon, Mr. Chair and Planning Board members. This will be a brief presentation, hopefully under 10 minutes, on how the Planning Board relates to the city's code of ordinances and the structure of a staff report in order to assist you with your recommendations and decisions. First, next slide, please. Article 2, Section 54 of the code establishes the planning board and defines its duties. The board is expected to consist of 9 members with 3-year terms, and members are not required to be a qualified elector of the city. Sections, next slide, please. Sections 54-35 and 38 list matters to be referred to the planning board as the granting of utility franchises or privileges, the adoption of amendments to the comp plan, future land use and zoning map amendments, the adoption of an amendment to the zoning ordinance or plan, and the annexation of any property. Section, next slide, please. Section 54-38 further broadly refers to the management of the comprehensive plan and amendments to it. So you guys are pretty familiar with all those terms, right? Thank you. Next slide, please. And as with most job descriptions, the Code of Ordinances includes other duties assigned to the planning board throughout different sections of the code. The board reviews subdivisions and plats per Section 74. Section 74, 7, 8, and 9 describe required information for the review of plat sketches, preliminary plats, and final plats. Preliminary plats have a list of 17 required items that we're to include with an application, while final plats have a list of 12 required items. Only a final plat recommendation then goes before the City Commission. Conditional uses addressed in Section 94-3 are heard only by the Planning Board unless appealed. There's a list of 11 criteria or findings that are analyzed by staff and considered by the board. These criteria include compliance with the comprehensive plan, ingress and egress, parking and loading areas, utilities, screening and buffering, required yards, and general compatibility within the district. That's not a complete list, but you get the idea. All of these criteria speak to the promotion of public health, safety, and welfare of the community. Next slide, please. Next are annexations, future land use changes, and zonings as addressed in section 94-38. Annexations utilize two criteria from the Florida statutes, compactness and contiguousness. The statutes require annexed properties to be in a single area and not create an enclave. So when you hear or read the report and you see where it says it does not create an enclave or it reduces an enclave, that's a really good thing according to the Florida statutes. The statutes require annexed parcels to be adjacent to existing municipal boundaries. If you guys are familiar with all that, that's contiguousness. Future land use map amendments look at three criteria as found in the comp plan. These criteria include analysis of natural and historic resources, the minimum amount of land needed in the community, and whether the amendment promotes urban sprawl. Zonings have an extensive list of 17 criteria that include items such as existing land use pattern, isolated district creation or spot zoning, density, living conditions, effect on property values and future improvements, and scale. While effect on property values is a consideration, good planning practice is not based on investment-backed expectations. The last item on the other duties list is found in section 94-195. It requests the planning board review and approve locations and setbacks for school and public bus shelters, bicycle racks, and telephone booths. And since I don't think I've ever seen a telephone booth here in town in the last 3 months, we probably ought to look at revising that section of the code soon. Okay, so Sunny, if you could pull up the staff report. I gave you all a copy of a recent conditional use application that you heard last month. And I'd just like to go over the structure. So on the first page, you're going to see what the request is, and then some background on the subject parcel. There can be a lot of things included in that, but it's usually a kind of a little bit of historical uses, more recent historical uses. And then as you scroll down, you'll see how it relates to the conditional use request and the requirements that are permitted within that zoning district. Sorry, the uses that are permitted within that zoning district. Then you'll also see the chart of surrounding properties and their existing uses, including their future land use and zoning designations. And then you'll see the analysis, which includes maps. There's a map of the subject parcel, and then a map of the future land use, the existing future land use, and the existing zoning. And those zoning and categories and land use categories are labeled because I'm not able to put in a legend on the map that we use on the software. Okay. You scroll down a little further, please. And then comes the analysis of all of the criteria that we're supposed to be looking at in these reports. Finally, we give a recommendation. The recommendation can be used as a basis for your board discussion and any motions that might be made. I'll be happy to answer any questions you might have.
I know the public comes here and they either agree with the change or they disagree with the change. And it could go either way with the vote of the board.
Mhm.
Have you ever had any like neighbors that come in and say, I do not want this in my, because of this reason?
Yes,
Do you still make a recommendation then?
the recommendation that I make in the staff report is based on those criteria. A member of the public can come and give their input, feedback. But for you as a board, you should also be looking at those criteria that are listed in the staff report. That's what's in the zoning code, and that's what we are tasked with following.
Mhm.
And again, there are some effects on property values that we can be looking at. But I think that you should try to base those effects on data. Data and analysis. Because in good planning practice, we are not supposed to, as a planner, not supposed to make a decision based on investment-backed expectations. So by that, I mean, just because someone walked in and said, look, I just spent $100,000 here, what do I get for that? Well, okay, what else are you supposed to be doing beyond, of course, we want you to prosper, we want you to be able to use your property, but we also need people to be good citizens and think about the benefit of to the whole community rather than just one person.
And I think that, is there anybody on?
Pastor Mulberry's on the Zoom and we are broadcasting live on YouTube.
So,
And everybody, when you go to speak, if you would press your microphone like you normally would, we are in a meeting.
it's annoying, folks. I understand. That's why I asked, because I didn't want to have to come up here and push the button. But from my perspective, having advised boards for a long time, county level for a whole long time, and then here for a whole long time, the tendency sometimes is for people to think that a rezoning or a conditional use or special exception or variance is a popularity contest. I've had them in one context or another actually call for a show of hands. How many are in favor of the audience? How many are against? And really, that's totally irrelevant. Now, sometimes in an effort to limit conversations, I represented Florida Rock when they tried to do some rezoning in West Putnam. We started at 3 or 4 in the afternoon and went till 2 the next morning in a planning board hearing. And sometimes in an effort to abbreviate the conversations, a speaker would speak and make points, and the chair would say, if there are people here in the audience who basically are here to make the same points, you can just raise your hand. And then if you still just have to speak, you can, but we know that you're on the same page if you just raise your hand. And that's one thing, but just saying how many are in favor, how many against really is not relevant, because the criteria we're to be looking at are those that are in our code. And I have asked Lisa, and we've talked about it in the future, kind of giving you a little bit in the staff report of here are the criteria the code says you have to address in this particular matter. If staff wants to make a recommendation, then fine. If somebody has a conversation they want to assert that is relevant to a particular point, of course, that's relevant. And they can even state opinions, that's fine too. But in the end result, you are the ones, not staff, not me. You're the ones to look at the criteria and the information you have in front of you, and then you express your interpretation of what you've heard and what you see in your vote. And so, a lot of zoning is emotion. A lot of land use decisions, especially of the property owners and the adjoining property owners, is based on emotion. I get it, it's human nature, but the code gives us the factors that you're supposed to be looking at as a matter of, for instance, consistency with a comp plan. That's a underlying ingredient to every rezoning decision. Is it consistent with the comprehensive plan? Now, staff's going to have an opinion. Sometimes it's a pretty easy call. You've got somebody that wants to do R1 and the comp plan says it's C2, heavy commercial. Well, that's not consistent. That's kind of black and white, but sometimes it's more vague, like it's a recreational agricultural use. And, that's been given some special considerations by our legislature. And so you may think it is, staff may think it's not. You're entitled to vote your conscience and what, your interpretation, that's what you're here for. As long as you're not just flatly throwing out the facts and the code. Like if you think that it's consistent and it's R1 in C2 or heavy commercial comp plan, well, you can't interpret that far. I mean, you don't have that much latitude, but I think that's the key. And when you take something up on appeal, and I have on multiple occasions gone to the appellate courts with decisions, you know, the key is based upon the record that's generated and the conversation and the motion and what you state as a basis for your motion, you know, can the appellate court look at what you've done and see that you're following the law? That's one of the major facts you're going to deal with when you get to the appellate court. And if it's just a matter of vote, you know, of saying, well, there are a lot of people here who are against it, so I'm against it, that ain't going to hold. Not if somebody actually takes it. Now, we've been fortunate in Putnam County for a long time in that, fortunate, unfortunate, call it what you want to, but we have not had in the past a lot of cases go to appeal because our property values were lower. A lot of times the projects were not a huge value. And so a lot of times if you got an adverse decision, people just live with it. But that's changing. People are more and more interested. The value is higher and higher. The projects are bigger and bigger. And so it's really important that we keep a touchstone on what our code is and what the facts are. And we avoid saying things that are patently not going to be deemed relevant factors if an appellate court looks at what you've done. So
See, my issue was, like, for instance, the example that I'm thinking of right now is when we had a guy come in, property owner come in, and you had, I think it was 2 neighbors in here, and then a letter that was written in about a daycare going in, and right next door, there was drug activity. It wasn't a once or twice. It was over 40 incidences. And us as a board, as, you know, business owners, residents of Putnam County and the city of Polacca, you know, and people that are trying to make decisions based on the better of the city for the safety, for everything. I just didn't feel like that daycare was an appropriate place. You know, I didn't think that was an appropriate place for a daycare. The city knew about it, you know, and it was still recommended to us as, oh, this is a good idea because of this, because of all of these, you know, things, but it really wasn't a good fit. And then it goes to the city. It got passed here, not because of me, but it goes to the city, and the commissioners didn't think it was a good idea either, because there was people that came there and said, look, I'm neighboring. I live across the street. I live down the street. And they all said, you know, the same thing that I was saying. And, you know, I got a lot of phone calls after that meeting, and it wasn't, you know, some were not happy with me saying no, you know, and some were happy that I said no, but it was just kind of like, you know, I'm fine with the phone calls and I'm fine with making that decision, but how do you break that emotion away? Because you had people here saying.
So from my perspective, if I'd been taking that to court, I would have looked at that as a condition that was remedial, that could be remedied, and not a characteristic that was inherent with the land or the circumstances. For instance, if you're talking about that daycare on a 6-lane highway with unlimited access and traffic and all that stuff being, you know, just a huge issue, that's a characteristic that you're not going to change with enforcement. That's part of the adjoining property, the characteristics of the land, a problem. But the allegations, as I recall, without getting to a different case, let me not go into that specific case, but an allegation of someone violating the law nearby, or, you know, someone having property that's not up to code or something like that. From my perspective, that's an enforcement matter that should be remedied. And that should be something that's dealt with. Now, I think that issue, there were some extenuating circumstances at the city level, weren't there? Weren't there some things that came up that she either withdrew it or there was an issue with? Yeah. Okay, I'm sorry.
They're gone. They're gone. Yeah, pull out.
My recollection was there were some issues with her modifying the
Fence.
building,
In the end.
modifying the building and not being able to meet right the code.
There's
But
2 other properties I'm thinking of that would be really good for her though, but.
I actually have the same question too, because I was thinking the exact same example is So how do we make a decision in terms of, okay, maybe like a safety concern, right? Because that was like with maybe like a neighbor next door. How do we make sure that we, I guess, are making the right decision in terms of when someone has like a safety concern with everything that's around or versus?
I think that's a legitimate issue. For instance, let's say it's a one-way road that goes to your property that's at issue, that's at the end. It's a residential area, and they're wanting to put a recreational use in that's going to have high volume traffic on a one-way road. Well, that's a legitimate concern. It's a one lane or two lane, one-way road, a dead end road that leads to the property through a residential area, and the property is going to have, it may be recreational, but it's going to be high use. Then that's a legitimate issue that I think has to do with characteristics of the land. It may even be consistent with the comp plan because of where it is, but if the roadway going in is a problem, big time problem, then that's that, in my opinion, is justification for legal justification for saying no to it. But I'm never going to criticize. Don't get me wrong. I'm not going to criticize. I'm not criticizing your voting your conscience based upon your good faith assessment of and your feelings about what you see. Except that I will say that I'm just going to ask you, and that's why I asked Lisa if we could put the criteria in the book and look at those criteria. If you find something in there that you can peg your emotions to and use that as the basis of your motion, then at least it gives us something to work with.
We used to always, I don't think we had to do that. I'm talking about years past. I don't believe we had to do that, but we all did.
Yep.
If you voted contrary, and the planner has to do the same thing.
Yep.
If you vote contrary to something, one of these articles in that analysis there, and this is not going to come across, nobody's here with us, right?
Got Zoom, YouTube land. I don't know who's on YouTube. Okay.
It doesn't take much imagination. I think one of these fit with, like, I think I brought up safety issues because somebody said something about that intersection being so close to Creel. That's a legitimate reason to turn it down.
Well, and see, to me, the safety issue would be, her sister coming and dropping off the kids at that daycare. She's not a part of the business. She's not a part of the owner of the building. She's not a part she's innocent bystander taking her kids to an overnight daycare because she's a nurse and she works at night.
That's
So,
what you
something
turn
happens
it
at night.
down on.
Yeah, but
Is
something
that
happens at
safety
night.
issue,
Yeah.
not
And see,
because the
that's,
guy's a
to me, it
drug
was a public safety issue. It was more public of the people that were gonna be utilizing that business. I just didn't think with all of the concerns of the surrounding property owners that live there 24/7.
I
you know?
didn't either see. I voted you and I think.
Well, we're going to try to modify our staff report so that I agree, Earl. That's what we did for a long, long time when I advised the planning commission. And what we try to do over the years, and we went through a number of different planning directors, but what we try to do is say, here's the criteria. Staff recommends denial based upon criteria ABC. And then the conversation would take place. And then it was apparent that the committee, the board did not agree with staff's recommendation. Then either the planning director or myself would say, well, I tell you what, Earl, if you're going to vote against that billboard, which we all know you would, then staff would suggest that you look at criteria D as being one that you might say under the circumstances applies, remember? And then your motion would be, deny based upon failure to meet criteria D. At least then, if we have to go up, I've got something in the record that says he tied his motion to defeat based upon one of the criteria that's specifically referenced in our code. Yes, sir.
Is staff able to also provide a loosely recommended verbiage for the motion so that way our motions are more accurate moving forward?
We can, I mean, I drafted what they call the Holmes motion for the code enforcement board, which they actually hand out. And we can do that same thing for you guys. It'll have blanks in it, i.e., and we can put a couple of variations together, but it can be something effective. I move to approve case number blank, 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 on the grounds that I find it meets the criteria, in our code, for the granting of a rezoning. Boom. That's all you really need in a motion to approve. But if it's to deny, you could say,
The county has something very similar to that where it says approve or deny, / approve, deny, variance, so-and-so because of.
Yeah. Well, that's been pretty consistent. I represented them for 17 years. They're both their boards. And as I said, you go up to the appellate courts a few times and you pretty quickly understand what you need for ammunition if you're going to win. I mean, when Norfolk and Southern wanted to put a lodge over here on Mortany Point, I represented the property owners on that roadway going to the point against Norfolk and Southern, and we won. Then we went to appeal and I won there. And then Norfolk and Southern hired me to get the lodge approved. And because of conflict reasons, I wouldn't do it unless my former clients agreed. But they trusted me to negotiate terms that would eliminate their concerns. That's why you have the separate entrance going into the Norfolk and Southern Lodge, and it doesn't go down that Mortany Point Road. And with that, we got approval. And but going up to the appellate courts with a couple of law firms on the other side, because Norfolk and Southern, they have resources. But going up to the appellate courts, you learn quickly what your record needs to have in order for you to win the case. And that touchstone to the code is just critical. You can disagree, you can have a different interpretation. Any of you can, than staff on a point. But as long as you've got something to base that interpretation upon, I think you're pretty good. It's where you're totally afield. You're not referencing this. You're totally afield. That's where you're setting us up for a problem, setting yourselves up for a problem. So that's why I think it's real important to look at those criteria, and then you can have your own interpretation. I think that's part of what makes this. That's why you have a board. Otherwise, you just have a machine that spits out a response. But that's what we're going to try to do for your help in the future. And the same thing goes on to conditional uses, except that you have more latitude there because you can impose conditions. You can't on zonings, as you know. You can't have conditional zoning, but you can't have conditional uses with have specific conditions that have to be met. And we'll try to guide you some through that as we move forward.
Free to say which case brought on this?
It wasn't one case. It was just, listening and watching.
Put me on the board. It was when they put me on.
No, last week or last month, was the first time that slam was that many.
That was a lot.
It was a lot.
And I think it was a good discussion. I think I felt good about all the decisions. The only one I didn't feel good about was that daycare.
Well, we used to do this, Earl, periodically, once a year or so, and at the county level too. Periodically, we just have a little brief session to put everybody, because the board changes, people get appointed, they leave, and it just was helpful.
But it's usually when you want to tell everybody, wake up.
Well, it wasn't really intended as an admonishment of anybody. It's just I hadn't done it for a long time as city attorney, and I think Ed had brought up a need for us to talk about
Yes.
the meeting, how the meetings were being run, and so it was just a good time for us to talk about it all. Lisa thought it was a good idea, so it wasn't intended as to be critical of anybody at all. Really wasn't, truly.
And Don,
One thing that I learned is you have to gotta ride by, we've gotta understand property.
Yeah, yeah. You gotta do your homework.
But yeah.
Well, I think with that particular case Dawn's talking about, if I remember right afterwards, that I was told that what they were bringing up about a man being there was not true. The guy that they were talking about, worried about doing drugs and stuff. I'm not saying the drugs weren't there or anything like that, but they kept going back to one particular person. And then later on, I come to find out that that wasn't a true statement.
And you know, you don't operate in here on a strict rule of evidence basis, but on the other hand, if I'm on the other side and that kind of stuff's coming up, my question is just basic credibility. You're taking people's word that they see something, you don't know how often, there's nothing documented. So, and we don't know if he's gonna be back tomorrow. And so we're making a land use decision, which theoretically it spans the future owners, et cetera, et cetera. We're making a land use decision on the allegation that somebody who's been in trouble with the law frequents a house that he doesn't own in close proximity. If I'm on the other side of that, that gives me a lot of ammunition. You know what I'm saying?
Mhm.
But it was the temporary staff that we had that brought up at the end of towards the end of the meeting before we voted. He said, well, I did get a police report and there's over 40 incidences. And I was like, why is this an issue? In my opinion, I thought that should have been, I lost it there. That's where you lost me completely. But I'm only one vote,
The
so.
drug thing, to me, that's all just something in passing. He could have been killed the next morning and doing a drug deal.
Well,
And you
let
can
me ask you a
follow-
question. If I own property and it's in the right area in terms of comprehensive plan says this property should be C1 and I've got a C1 use and I've got land rights just like anybody else does. And I come and ask for approval of something and you say, yeah, but your neighbor 3 doors down is a bad person. And so that he's a bad person because of that. We're not gonna let you have your land use that you're seeking. From my perspective, that's a problem because if that person's a bad person, then the cops ought to be taking care of it. And he shouldn't be a problem to my property. If it's an enforcement issue, that's nothing I can control. And so that's why I say if I've decided I wanted to put, a daycare on in a high traffic area with unguarded cross sections and 38 accidents in the last year. Okay, that's something that's a characteristic of the land. But the fact that somebody's frequenting a house a few doors down, if I'm on the other side of that, I would have taken a lot of exception to that. I think the appellate courts would have too.
I can see that. The other issue is, the Dollar General we approve as a retail store.
Yes, ma'am.
Which one?
The one
Yeah,
right next to
Krill.
Family Dollar on Krill.
Well, see,
I got a drink.
okay, so let me address that.
How is it, at what point does the city of Polacca say no more?
At what point does the city of Polacca have the authority to say we don't want any more contractors in town? We got enough. We're not approving any more buildings for
Yeah.
contractors. Got enough drugstores, no more drugstores. At what point do we basically restrain trade and competition by saying you can't do anymore? I mean, I apologize, but I was raised thinking free market society was the way to go. I mean, if the market will support it and I've got the money to put something there that people want, why shouldn't I be able to do it if I'm in the right place? So from my perspective on Dollar, whatever, I get them confused.
Dollar General.
General Dollar,
Yelling black.
whatever. They're coming in, taking a high store, wiping it off, putting a $1.5 million structure or whatever on the tax rolls there. If they're going to do that, then and they want to invest in Putnam County and it's a commercial area, why should I say no? We got enough.
But forgive me,
Well, in the same instance with that, when that particular thing, which you're talking about, Don, and I understand what you're saying, but, and everybody's in an uproar about it. Everybody's condemning the planning board for approving that. But the same instance, there's only 3 of them in Polacca.
Well,
And in the same instance, Polacca is a food desert.
And the other instance is, if people say, well, there's one, 2 doors down, and I'm saying, okay, if I build a better gas station here, what normally happens to the other gas station? Just saying.
But forgive me, I thought that that was going to move in either, if I'm remembering right, I thought that was going to move in either way. We were only voting if it could connect to city water or not, I thought. Am I
No.
remembering that
No.
right?
I think y'all voted on annexation.
Yeah, we had to vote.
Or
Yeah.
was it?
I didn't, I
It
thought
was-
that, I thought it was
There
going to be a family
multiple.
dollar no matter
Yeah, there
what. Was
multiple.
it?
I think
Maybe
y'all
I'm
voted
not
on whether to
remembering
take
right.
it in, and then if it comes in, what does it
They-
go in as? Comp
And
plan.
if they weren't, in the beginning, they weren't telling us what they wanted to do there.
And see, that's another interesting point. Academically, if you shouldn't have to tell you what the use is.
I understand.
In a pure
Well,
world.
And they said retail store, and I
Exactly.
think
Yeah.
you did ask, because I was like, it was over here, but it was, and I was like, she didn't, and then when she said don't, I was like, oh.
And it wasn't until you came right on past, is it a dollar store?
Right. She wasn't going to tell us.
But
so
think
she
about it
didn't.
this way for a minute.
I just want other retail stores.
Slot, then it's fine.
It's irrelevant.
But that one and the previous, one, the last two in the city of Polacca, they sat up here, it was kind of like the gambling fish stores, you know, it's just phenomenal. Remember that? Oh, it's just like that. Well, both of the dollar stores said, oh, no, we're gonna preserve those trees. And everybody
I knew that
thinks
was
I'm
coming.
crazy as hell because I like trees. But I do.
Chairman.
They said it and they never even.
Mr. Wallace, would you turn your mic on, please? Turn your mic on.
Just leave it on.
Yeah. They said that they were, don't shake your head at me. They said that they were gonna take care of the trees, you know?
They
And
did.
neither site did they adhere, in my opinion, to our landscape ordinance.
But that's got nothing to do with zoning.
Well, was that a zoning?
That was a annexation, zoning, and land use, comprehensive plan. So my point is, what if I don't have a use for the property? What if I'm taking a piece of property at a busy intersection that's purely commercial, and I want to bring it in the city, and I want
I'm-
commercial zoning, and I say, I don't know what I'm gonna do with it, but it's gonna be commercial.
I'm all wet then, because I was thinking both of them were conditional uses.
No, that wasn't a conditional
But
use.
in any case, all right, I don't have a leg to stand on, but where do I bring them to task to follow the city ordinance?
Code enforcement, I mean, that's a code enforcement
By
matter.
that time, the trees are gone.
Well,
I mean, and they cut down when we did our landscape ordinance, those trees were termed heritage trees.
which trees are you talking about
The
now?
oak trees.
You're talking about on
He's on
Main
Main
Right
Street.
up here
You're on
and
Main
over-
Street.
And over there at the intersection, Palm and.
Intersection
Creel.
2.
Palm and Creel,
I didn't remember that big oaks there, but
yeah, and big cedar tree. And so. And I'll bet you it's like the guy up here
You
at the
can't do
corner of Ninth and Reed Street. The little liquor store. All right, he was gonna landscape that place, he was gonna meet, and that was a conditional use. He was gonna meet all of the landscape ordinance requirements, he was gonna do wonders. He went out there and he cut, I think there's six little 1x1 holes in the concrete and put a bromeliad in the bright sun that's supposed to be in the shade to live. And that was it. And then they were gone after 3 days but we're still sitting here and he's still up there and
Earl, we need to start you another business, Earl's Lawn Service.
no, I'm not,
No, I'm gonna make
I like
Earl
drinking
the
my
code
beer and
enforcement
playing with the
officer.
flowers,
Speaking of trees and speaking of this sample here, they did cut that down. Did you see that by the
Finally,
wax? You
finally.
could see there's a stop sign there.
What are y'all talking about?
Yeah, it was a
They
rubber
cleaned
tree and
that-
they did cut it down.
They cleaned that whole place up.
so Earl, that would be a code enforcement issue. It would also be a failure to comply with a conditional use. It is enforceable. But somebody had to make a complaint, and, you know, we're coming up to speed on our code enforcement.
Which we wasted our ink printing codes because we haven't been very good at enforcing codes.
Well,
With the police department, at one time, if you call somebody about a code enforcement, don't shrug like that on the set. If you call somebody about a code enforcement issue, they referred you to the police department. And when you call the police department, they laughed at you and says, we got drug addicts. We're trying to pick up. We don't care about.
that's why I took code enforcement from the police department and brought it back down here and put it across the street.
You did good.
And, you know, we are doing things. We, because of everything's blamed on COVID, I know, but we could not get any code enforcement officer in school from last May until September. We just got our code enforcement people back 2 weeks ago. First school we could get them in. Everybody shut down. So we have two now that are code enforcement certified. We've been having a hearing almost every month. We've missed 1 month, I think. And we've gotten a lot of cases in compliance, and then we've taken cases to the special magistrate, an average of 6 per month, gotten a lot of, you know, fines and other things in place that will let us go forward with foreclosures, which we're going to do 6 months after the fines start if we can't get compliance. So, but you gotta, you know, you can't go from 0 to 100.
I know that.
In 15 seconds.
I'm a very practical person. I really.
That's what I've always said about you, Earl.
Mr. Holmes, I think you need to mark that down. You missed your chance.
What's that?
Mr. Wallace said you were right. You did good.
Oh, I've told him he was right before.
I've never heard.
You're not always it.
Just rewind
I
the tape.
understand. I'm just
Rewind it
saying.
and re-listen to it
Yeah,
again.
I've never heard it.
Um,
Do we have any more questions or anything?
Well, I will say that the Dollar General store owns Family Dollar. So they're moving in next to a company they
No,
already own.
you're wrong on that, George. I found that out too. I've thought that for
Somebody-
years.
I was told that they,
I'm not,
that the same mother company has both of them. It's not
No.
under Dollar General, but the same mother company
no,
owns both. That's what I was told.
Don't think so.
The dollar store out in the Publix Plaza,
Dollar Tree.
Dollar Tree.
Yeah.
That corporation owns Family Dollar. Dollar General is on its own.
Yeah, that's the green. I
'Cause I
don't
used
know
to
their
say that
names.
all the
I can't
time.
keep them apart. The one out by Publix, that's the green.
Right.
And then the one that is the fastest corporate, or it was 8 months to a year ago, the fastest growing corporation in the country was Dollar General.
Right.
And then the other one, which they got all the flash of color.
Right. That's Family Dollar.
Store, I think,
Family Dollar.
Family Dollar, yeah.
Okay, well, if we don't have it, let's move on along. I got places to go tonight,
Yeah.
people.
Yeah.
So I guess I've got Robert's Rules of Order. I'll be brief with this. There's a lot of information in Sonny's presentation here, but I'm not sure that some of it really isn't Robert's Rules of Order. A lot of people think Robert's Rules of Order is a law. It's not. And our ordinances, our code of ordinances specify that Robert's Rules of Order will be used at the city commission level. It doesn't specify anything about other commissions, but you got to have some way of keeping order. So it's kind of something you can revert to. Don't ever hear about it in law school. People think because you go to law school, you know about Robert's Rules of Order. Trust me, it's never mentioned in law school. And that's not what you're worried about. But I downloaded a copy and it's on my phone. You can just go to Google and look at Robert's Rules of Order. And I put it in my book section and it's free. And you can, you got a table of contents and it's, we got Wi-Fi internet in here. You can look it up anytime you want to if there's something that comes up. But the main thing is in any procedure that you adopt, and Robert's Rules of Order it's good because it gives you a way of breaking a tie. But there's just some basics, that you need to do to keep in touch with in order to make the meeting run. 1, have a motion. 2, have a second. 3, have discussion. 4, don't have more than one person talk at the same time. And then 5, you go to a vote. Now, there are some rules that come into play when, you have specific topics like, let's say you want to reconsider a motion. What's the rule of that? it's easy. You can look it up. It's pretty easy. Someone from the winning party has to make the motion for reconsideration. It has to be done during the same meeting under most Robert's Rules of Orders provisions, and then, it has to be a positive vote. But the key being, someone from the losing party can't bring it up for reconsideration. It's got to be someone from the winning side. The audience, that's something that's just sometimes it's difficult to control. But well, the biggest problem you may have on an emotional issue is people talking out here, not talking to y'all, people not respecting the conversation of someone who's presenting, people applauding and catcalling when someone's saying something they like or don't like. That's the kind of stuff that can get out of hand in a heartbeat. And that's where the chairman has to come in strong and just say, we're going to talk one at a time. We're going to be respectful of what the person that's there is saying. You may not like it, but they let you talk, you let them talk, and then it goes from there. So
That's one of the biggest corrections, I think, that are made, telling them to speak to the board, and not because they'll turn around and
argue with each other.
And they're supposed this,
So there was anything specific in Robert's Rules of Order that you wanted to talk about?
I mean, just mainly the being recognized, to speak. And there's a lot of issues with that. And that's not just general one person. We need to have the chairman recognize us just for the fact that you're speaking, not nobody else is speaking at that point. And then, when you're quiet, then another person gets the chair to recognize them.
And that has there's a practical reason for that as well, because at some point, somebody may end up transcribing one of your hearings. And if two people are talking at the same time, you may not get a clear record of what was being said by any one person. So that's why courts are strict on not having more than one person talking at the same time. So, but that's, again, is going to be for the chair to,
Right.
To politely but firmly enforce is be recognized by the chair before you speak.
And I think a lot of the issue is we are so informal and we're all friends with each other. We all know each other. So it's not, we're not thinking about it when we do it. But sometimes, I'm guilty of it. I'm probably the world's worst at talking over somebody. And you think you are? Yeah. So, if we can be recognized by the chair, it causes a lot less confusion for, as it's being recorded, as being transcribed, like you said, the people in the audience, that they see us doing that to each other, they're more apt to jump up from the chair and do the things that you're talking about.
Absolutely. Biggest, when it's emotional, that's when you have a problem. When there's something emotional before the board, or as I said, land's always emotional. What's the old saying? People will kill you over a dog, a kid, or land. And that's, I don't know, now it's like you can get killed over 15 cents too, but back in the day, at least, those were the topics that you thought of most were, kids, pets, and land. But that's when it's really important that you keep order from the outset, because if one side gets away with stuff, the other side thinks that they got a right to have,
Right.
A counter. So, and I've seen them throw people out of hearings. And if you're going to have a hearing that you think is going to be real controversial, like when we had the debates about the adult entertainment
Right.
stores. They needed to keep control of that from the first minute of it, so that you didn't have stuff going totally off the rail. But
Mr. Walsh, you had a question? I'm recognizing
I
you.
was just gonna say, I'm not rude, I'm just passionate.
Okay.
Obviously, the purpose of the board is to make the decisions and judgments, but if we come to a motion that we're not confident in one way or another, for whatever reason, as a board member, am I allowed to not cast a vote?
not according to, I don't know if Robert specifically covers it, but the rule is that unless you have a reason for abstention or abstaining, that, is based upon conflict, which you articulate and ultimately confirm in writing, you're supposed to cast a vote.
So
Yeah.
if something gets brought up in the meeting, something maybe I hadn't considered, and I wanted to look into it more to confirm it accurate or not, because it's a big swaying factor to my decision. How do I proceed with that? Ask it to be tabled?
You can, sure, you can
Okay.
ask.
That's a motion.
Yes. He-
So that kind of brought that up about the other day, we had it to where there was, nobody did anything. We would say the motion died for lack of.
Mhm.
Second,
Oh. Or, yeah, or
For lack of motion.
lack of motion.
or, okay, wasn't a motion then.
And that's fine. That's.
That's a decision.
That's a decision.
Yeah, that's a definite decision.
From the planning commission standpoint, non-action or a tie vote goes up as a recommendation of denial. Even a tie vote. I was gonna look at,
Edie just brought
motion
up,
to table may be one of those motions that doesn't require a second.
Edie brought up a deal just
We've always had.
where
I think.
you rode past the property and looked at it. Probably 2 chairmans ago, he advised us not to go past any property, don't, because you'll run into a neighbor that's going to have an opinion and so forth. And so where I used to stop and look at some properties, I do ride past the properties, look, but I do not stop. But his deal was, you may run into a neighbor that has an opinion and then you're,
Well, it wasn't even the chairman, it was the planning director that told him, if you remember,
Well,
that told us not to.
and here's the thing, and that really boils down to more of a sunshine law or a public meeting issue. The whole theory of a hearing is that you hear what you base your decision upon so that those in favor of it and against know what you're relying upon in making your decision. I mean, just fundamentally, that's what it's all supposed to be about. You come in this room just like a judge, and you hear in this room the circumstances upon which you base your decision, so that if I'm against it, I know what you're hearing. I can object to it or try to counter it. And if I'm in favor of it, I know what you're hearing, and I don't get somehow sabotaged by something that you heard that I have no ability to contradict. So just an easy instance, you go out and look at the wrong property by mistake. It can happen. And you come in here and you don't tell anybody what you saw, what you didn't like, but that's in your mind, you vote against it. And I'm the proponent, I'm the applicant, and I have no way of saying, no, Ed, you looked at the wrong piece of property. Mine's one across the street that had big oak trees to be taken down. Pardon me, Earl. But so
I'm
it is-
trying to just be passionate, not rude, but you're making it hard.
We were friends when we walked in, Earl. It's okay. We're down.
So in its purest form, if in its purest form, I would say you didn't know anything about the case until you walked in the door. But let's face it, in a small community, that's not practical. So all I ask is that if you're gonna go by and look at property, and normally what we used to do when I represented the board was I would have a show of hands, how many people have gone out and looked at the property? And, one or two, would raise their hands. And at least if I'm either side, I know you've gone and looked at something. And, it helps. And then the next question is, did you talk to anybody while you were there?
Mhm.
Because you might run into the applicant and he might show you all about what he plans to do, but nobody but you knows it. If I'm on the other side, I want to know that because he's told you something I don't get to say, no, he can't do that. He doesn't have the ability to do that. So the only thing that I would ask is that you make it known, you went and looked, and you make it known that when you looked, you talk to anybody. And of course, the safest thing is don't talk to anybody and just say, I'm sorry, I'm just here to look. Can't talk to you today. Then you got nothing to say, but I didn't talk to anybody.
You answered my question.
And that's the ex parte.
That's the ex parte that you also have, you're asked about, did you talk to anybody? You don't have to talk to anybody about the case outside of these walls. You don't have to. You're not an elected official. You don't have constituents who have a right to talk to you. You don't have to. But if you choose to, I would not tell you that you can't. I don't think I have that power. But if you choose to, understand that you're going to be asked, did you talk to anybody about this case before today? And if you say yes, then you're supposed to state the substance of your conversation. Now, I'm on the other side. I'm going to want to know, well, tell me more, Ms. Rawls. What did you talk to Earl about? You know, did he give you that whole sob story about billboards being a blight on the city of Polacca and blocking traffic and causing people to run off the road and hit trees and things? Heritage.
Not trees, heritage oaks
That's
down.
right. Did he do that? And then if you say, yes, I'm gonna be.
Bloody when he gets through.
So that's why I tell people, you can do it, but just understand you're gonna be asking about your conversation when you come here. And that's required.
Well, the other day was, okay, whole Main Street and 21st.
Yeah.
No signs, that was so confusing. If it would have been the alleyway behind the old Pick and Save, running along that fence before the railroad bed, okay, that would, and even the driveway going into,
Did you have a diagram? I didn't, I wasn't.
it was bad, there were bad. I mean,
But Lisa, in defense of her, in doing the things that she was doing, she wasn't here when Pick and Save was here.
I know.
You
No,
know,
that's
she,
for me.
21st
Yeah.
Street.
As
that's the
far as-
driveway.
as far as,
Yeah.
St. John's and to.
And
As
for
far-
me, it was your questions, and then it was his comments, and then it was his questions. And then I'm putting all this information together because I know I drove by, didn't get out of my car, drove by and saw, and I thought, I'm totally fine
oh,
with all
she,
this,
not me.
but didn't realize
I'm not.
All
all
claiming-
of the properties behind it. And
I'm
having
not
the
claiming to
discussion
know
open-
everything, but I tried
No,
to explain.
but that was a big
'cause I
deal
surveyed the whole
because
thing
I went
years
from
ago
one end to
for
the other, and that was
somebody.
good.
You still remember that?
Oh, yeah,
Okay.
yeah, I'm sure.
He's sharp.
But I tried to explain what 21st Street was, what Main Street
Yeah.
was.
And you're,
And people have they don't grasp that the street can go right on out through the woods and across the canal and the ditch and everything you
Yeah.
got there. But it's still public right of way. It's just not open. They- And just open.
and your explanation of the way that road, if it was to come open again, if the property owner, there's some property owners in there that could not get to their property. If that road came open again, made the most sense out of everything.
Yeah.
See,
Go ahead.
They could have gotten to their property, but it was not the most beneficial route to them to
Well,
go
that's what
over to Madison. If you got a business in there,
Right.
you want to get to Reed Street with the trucks and get right on out of town. You
Right.
don't want to go wiggling around the bike path out there somewhere.
Right.
No, because when you chop down those trees, you gotta get right to Reed Street and get out of town before Earl sees you.
Oh, the
You
trees
mean-
are all down.
You mean those heritage bushes that are out there?
Yes.
I didn't say it.
Yeah, you're the city man. You call these people down.
Not my authority. I don't have that. I don't have that authority.
All right, is everybody, are we good with Robert's Rules of Order?
Anything else I can
Today
answer?
we are, but when it gets emotional, I'm not claiming anything.
Well, that's what I'm asking. Is there anything else that Mr. Holmes can answer for us right now?
Well, I would like to have that, like we're fixing to make the motion, you know, we have.
Right.
Because you do kind of get a little nervous and you want to be able to say the right thing, so we can kind of fill in what.
We'll do that. We'll do that for you.
Yeah.
And that's good for the record too.
If you could just put a laminated, Sonny, if you could just put a laminated sheet at everyone with those rules like that, or that, a motion, and that,
We'll
how
put
we
a
could
couple
just,
of them together for you. We'll do a motion to table, a motion to approve, a motion to deny.
and if we could have those laminated and sitting at our seats, so that when, one of the board members decides to make that motion or make that decision, they can pick that up and read it, and I mean, because at points, when you first get on a board, like, like some of us, when you get nervous and you start stumbling, and that's just not human nature, but it'll give you a little bit more confidence, thank you, in what you're doing.
Sure. You have in the beginning what the person is asking for. It's spelled out for us in the beginning of our staff report. So you take that, I move that, you can read it verbatim down there. And I always throw in at the end the staff's recommendations, because otherwise they're not in there.
But Earl, you've been doing this for 100 years.
Huh?
You've been doing this for 100 years.
Only 99.
85.
I'm gonna leave on that note.
Thank you, Mr. Holmes.
Thank you.
Sonny?
Are they gonna do the sunshine?
Yeah, they're doing that. Sonny's doing that part of it. They said they timed her. She's 6 minutes. Let's go.
All right, we'll try to be as fast as we can. Hi, that's loud. I'm Sunny. I'm the acting city clerk of the city of Polacca. Ironically, I've been chosen to present to you the sunshine law. No pun intended, right? We're gonna try to go through these slides kind of quickly. I would recommend that this PowerPoint can be downloaded from the state of Florida's website. This was a PowerPoint that was created by Attorney General Ashley Moody. Next slide, please. I get to say that, wow. It's the arrow down button. Voila. All right, Florida's Government the Sunshine Law provides a right of access to government proceedings at both the state and the local level, so it includes the planning board. In an absence of a statutory exemption, it applies to any gathering of 2 or more members of the same board to discuss the matter which will foreseeably come before that board for an action. Lynn Tipton, a lecturer for the Florida League of Cities, says where 2 or more board members are gathered, there the sunshine law is in the midst. So that's a great thing to kind of keep in mind. The scope of the sunshine law includes anything that's discussed in private discussions with each other about board business, either in person or by telephoning, emailing, texting, or any other electronic communication. When Mr. Holmes was saying, if you speak to someone about it, if it's put in writing, it's then governed by the sunshine law. Someone can ask you for your pull a public records request for your text messages about that case, for any emails you may have sent about that case. Anything it's under the sunshine law.
Wanna-
Next slide, please.
Real quick, Sonny.
Yeah.
Just for clarity, that's only amongst board members, correct?
If you were to text someone about a case, a private person, it's governed by the sunshine law.
If you put it in writing, because
It's in
I can
writing.
text it to Joe, and Joe can be friends with Ed, and he could say, oh, look what happened, Don said.
Okay.
If
What
you're
if it-
using,
it's-
if you're using your personal device for anything at any time as a board member, it can be subpoenaed into testimony or asked for, if you're using your, that's another thing, Sonny. I don't know if there's any way that we might be able to get personal, or not personal, but city email addresses for board members. So that if somebody decides that they want to email us or something like that, instead of it going into our personal email accounts, because that would also be, they would take our personal email and use it for that also. They would subpoena our whole thing. And if we're talking to somebody we shouldn't be over here about something totally different, I'm not saying that I do that. I'm just, anything, they can take your whole email account, put it into public record.
I'd be glad to ask the city manager. I know in the past why the planning board wasn't given city email addresses is because you're not required to respond to that. And I
Understand.
don't think anyone wanted to make you guys feel like you're required to respond to a member of the public about a planning board matter. You're not required to do so. You can, like Mr. Holmes was saying a minute ago, you can tell them I have no comment.
Right.
Best thing, if you're not in this room, don't talk about it. Period.
So that's why it's not been.
That's fine. I'm just making that.
And one of the planners or managers or something, I've gotten emails where just you asking if we're gonna be there. And they reply all. We were told at one point, never reply all.
Never reply
because
all.
That's a violation of the government sunshine.
Right.
because
Correct. Yeah, never reply all to another board member because it is technically considered a violation. Next slide, please. Next slide, please. There are 3 basic requirements of the sunshine law. Meetings of public boards or commissions must be open to the public. Reasonable notice of such meetings must be provided, and the minutes of meetings must be prepared and open to public for inspection. Next slide, please. Scope of the sunshine law. The sunshine law applies to advisory boards created pursuant to law or ordinance and otherwise established by public agendas or officials. Next slide, please. Staff meetings are not normally subject to the sunshine law. However, staff committees may be subject to the sunshine law if they're deemed to be a part of the decision-making process. Next slide, please. The scope of the sunshine law, only the legislature may create an exemption from the sunshine law. And there's a little bit more information there about about how exemptions are passed by the legislature. Next slide, please. Boards may adopt reasonable rules and policies to ensure orderly conduct of the meeting. The Sunshine Law does not allow boards to ban non-disruptive videotaping, tape recording, or photography at public meetings. And that's kind of echoes some of the things Mr. Holmes was saying a little while ago, that if you choose to adopt Robert's Rules of Order, it's fine to maintain an orderly conduct, but as long as the public's maintaining orderly conduct, they have every right to view the meeting. Next slide, please. Section 286.0114 of the Florida statutes provides, subject to listed exceptions, that boards must allow an opportunity for the public to be heard before the board takes official action on a proposition. The statute does not prohibit boards from maintaining orderly conduct, as I was just saying. This is why we always call for public comments in the beginning of the meeting, and then usually after, once the board has started beginning discussion, to make sure that everyone has their voice heard. And there are criminal penalties such as civil action and suspension or removal from office. Next slide, please. Public Records Law. Florida Public Records Act from Chapter 119 of Florida statutes provides a right of access to records of state and local governments, as well as to private entities acting on their behalf. If a material falls within the definition of a public record, it must be disclosed to the public, which we just talked about a little while ago. The next slide's got more information on what public record means. I'll let you read it over at your leisure, but it's pretty much what we were just talking about. If it's in a written form, it can be a public record. Next slide, please, talks about providing public records. Public records cannot be withheld at the request of the sender. A requester is not required to show a legitimate or non-commercial interest as a condition of action. A request cannot be denied because it's overbroad, unless authorized by another statute. An agency may not require that the public records be requested in writing or the requester to identify themselves. That's talking about how a public records requester can be anonymous if they so choose. Currently, for the city of Polacca, our city attorney is our records management liaison. And the next slide talks about providing a public record, and this is kind of some of the things that the records management liaison must adhere to. Then the next slide, if you would, Linda, talks about fees. The only real fees that someone can charge to for a public records is the actual cost of duplication, and a reasonable charge for extensive labor. Next slide talks about retention of those public records. Here at the city of Polacca, like other government municipalities, we do follow the Florida records retention schedule. Next slide, please, Linda. And then the next slide shows penalties for non-compliance with the public records law. And then the next slide, if you would, Linda, provides some additional resources. The Office of the Attorney General has plenty of resources on what public records are. The First Amendment Foundation also provides a written and electronic copies of the Sunshine Law. That concludes that part of my presentation. Do I have any comments?
The Form 8B, you say you were going to say something about that.
Yes, sir. The Form 8B, in the beginning of your normal agenda, we call for ex parte disclosures. It's before any case is being held or heard. It's a time that the chair asks the board that if there are any ex parte disclosures, whether it be verbal, whether it be written, be disclosed to the board at that time. That way, when the case is heard, there's no surprises. Oh, by the way, I need to disclose. It's up there in the front of the meeting. Everyone who's from the public is present and can hear that you have that ex parte disclosure. Once that has been disclosed, we ask that you fill out Form 8B as required by statute to document in writing what that ex parte communication was and why you're abstaining from your vote. Yes. And I would file it, the clerk files it with the minutes of the proceeding.
Any questions? Ms. Grant? Okay. We'll move on then to section 3IV.
Yes, sir. This next section is also mine. This is talking about the statement of financial interest, which every planning board member must prepare and send to the local supervisors of elections. Typically, the first statement of financial interest, Form 1 that you will fill out is done within 30 days of taking office, and it's done for the year prior to when you began your board election. Every year, the supervisor of elections will contact you to fill out your form, and then when either your term is up and you choose to no longer seek another term, or if, for whatever reason, you're no longer on the board, within 60 days of not being on the board, you're required to fill out what's called the 1F form, which is your statement of financial interest for that year up until the point that you left the board. The only thing that I would point out is if you leave the board on December 31st, you actually would end up filling out 2 forms for that year. You would fill out the form that they would send you in July, because if you were on the board as of December 31st, you have to fill out that year's form as well as your 1F form, but that's one day. It does happen, but if you left on that one day. Any questions regarding forms, statement of financial interest, or the Form 8B?
Well done.
All right, thank you, guys. I appreciate the opportunity.
While Ms. Krantz is standing there, do any of the board have any, or of Lisa too? Does anybody have any questions about anything that's been asked or done tonight? This afternoon? Of staff? None?
Try to stick to the criteria that we have listed in the zoning
Hmm.
code. That's the main point.
Right. Yeah, well, like I said, I asked you before, about keeping me in line. That's important.
Are you sure you want to ask me to do that?
Well, I mean, when you're putting the presentation on, yes, ma'am, I do. You just don't know what I'm asking you to handle.
All right.
But, okay, thank you very much, staff. That was very informative.
We appreciate each one of you for everything you do for the city. It's sincerely appreciated.
Okay, is there any other questions or anything anybody would like to say at this point in time?
Can we keep, are these hours provided,
Sonny?
Yes, sir.
their hours?
Yes, sir.
So we can ditch our other one? Is this all we do?
Which other one you talking about?
I've got a notebook.
Some of us got a notebook, some of us got a little certificate,
People got recognized.
some people got
Yeah, so
recognized.
you feel what?
Yeah. So,
There was no orientation and not.
well, I got a municipal code book. And yeah, mine is huge.
They
So I
rented
got
the
that.
mall hunt house for some of us. We had a huge get together buffet. Oh, it's awesome.
She's stirring, Edie, she's stirring. All right, with that being said, can I have a motion to adjourn?
So moved.
So moved and seconded. Meeting agenda, I can't talk now, meeting adjourned. Thank you for your participation.